Garden State GSCLE. 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 Garden State GSCLE.
I want to break this down in such a way so that if you have to stand up in front of a judge and make an argument, you can make a logical argument step by step by step, so you're explaining it like you're explaining it to a small dog, okay? Because that's the level you have to deal with most municipal court judges. Start off with the proposition of what is the burden of proof in these types of cases, okay? Now, it was initially established in State versus Johnson, and then reconsidered by the Supreme Court in Romano versus Kimmelman back in 1984. So take a look. The Justice Handler, ready for the court, says, in this case we hold the burden of proof prescribed under State versus Johnson is to be followed to establish all the conditions of admissibility for the breathalyzer test. In Johnson, conditions of admissibility must be clearly established. To avoid any confusion over what is intended by this level of proof, it should be understood that it conforms to the standard conventionally referred to as clear and convincing proof. Now there's the pinpoint citation of the Romano versus Kimmelman. Remember, this is in the context of establishing conditions of admissibility for a breathalyzer. The definition of clear and convincing evidence is, it's in several cases. Just for convenience purposes, I pulled it out of In Re Seaman. And you can see that the definition is it's proof that produces in the mind of the trier of fact a firm belief or conviction as to the truth of the allegation sought to be established. Evidence so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the precise facts in issue. Now, guys, when you're trying one of these cases, you got to bring a copy of this with you, and I would read it into the record ahead of time, give the judge and the prosecutor a copy of it so that everybody understands what we're dealing with as a matter of law. You never want to rely upon the judge's personal idea or predilections about what the definition of clear and convincing evidence is, because it may be something that's totally wrong or completely foreign to what the actual definition is. It would be like trying a jury trial, criminal jury trial, and not having the jury charged on the definition of proof beyond a reasonable doubt. So very, very important that you get this on the record and get it into the judge's mind. The burden of production, in other words, the party who has the burden of going forward with the evidence, is the state. Okay? Again, this is another determination by the Supreme Court as written by Justice Handler in Romano versus Kimmelman. We further hold the responsibility for establishing all the conditions as to admissibility of the breathalyzer test is properly allocated to the state. This is the rule with respect to the usual conditions of admissibility under State versus Johnson. All right? Now, having established the burden of proof and the burden of production and the definition of clear and convincing evidence, what is it exactly that the state is going to have to prove to get these results in evidence? Now this is very interesting because the Supreme Court, and you really have to take some of this on faith, but work with me for a second on this. The Supreme Court looks back in Chun to Romano versus Kimmelman and basically cuts and pastes parts of Romano versus Kimmelman and takes the procedure for breathalyzers, modifies it slightly, and makes it available for Alcotest, okay? Now, I have to tell you, in terms of full disclosure, there is nothing in the Chun decision that says that the burden of production is on the state, that the burden of proof is by clear and convincing evidence. None of that stuff ever comes up, okay? They don't discuss it. But I think it's a safe bet to assume that the court, since they refer back to Romano versus Kimmelman as the model that they're basing it on, that same burden of proof and burden of production is still in play now and has not changed. It's just not specifically mentioned in Chun, although when you see some of the case law coming out, the appellate division and law division have certainly assumed that that is the burden that's carried forward into Alcotest litigation. But I just, as a matter of full disclosure, technically the Supreme Court has never talked about that, at least in the Chun context, okay? So, going back to Romano versus Kimmelman, what is it that the state has to demonstrate by clear and convincing evidence in order to have breathalyzer test results admitted in evidence? State has to establish three things. Each one has to be established independently by clear and convincing evidence. They are, 1, proper operating condition of the machine, breathalyzer. Number 2, requisite qualifications of the operator. And 3, proper administration of the test. Okay? Now, what Justice Howens does in Chun is to take these three requirements, but she expands them, and I think she expands them in some fairly significant ways, as you're going to see in a second, and then imposes upon the state that obligation. Take a look at the same language coming out of Chun. There, meaning in Romano, we demanded, this is Justice Howens writing in Chun, we demanded as a precondition for admissibility of the results of the breathalyzer, the state was required to establish. Now notice that how she expands the language here. This is not what they said. She's like rewriting history here. The device was in working order and had been inspected according to procedure. That's not what they said. They said proper operating condition of the machine. Operator was certified. They actually said requisite qualifications of the operator. This last one's the most important. Test was administered according to official procedure. They actually said proper administration of the test. So the test for the state now is to establish these three conditions of admissibility in order to get the Alcotest results in evidence, each one by clear and convincing evidence. Device was in working order, had been inspected according to procedure, operator was certified, test was administered according to official procedure. So you stop to think about it, if you can't demonstrate that the test was administered according to official procedure, and what the official procedure is told to us in the body of the case, then the state would not be able to demonstrate that element by clear and convincing evidence, and the results would not be admissible. That's the logical flow from this. Now, I want to talk about how we get this done, all right? The way you go about establishing the conditions of admissibility, not only of Alcotest results, but of any piece of evidence, is done through an Evidence 104A hearing, all right? Now, I want to just kind of give you some background about 104A hearings. The genesis of Rule 104A actually is found in New Jersey Rule of Evidence 101, okay? Specifically 101 A2E, all right? And here's what it says. First of all, court proceedings relaxation, okay? That's what we're dealing with, a relaxation of the rules. These rules of evidence shall apply in all proceedings, criminal or civil, conducted by or under the supervision of a court, except as provided in 1A, which deals with privileges, I believe. These rules may be relaxed in the following instances to admit relevant and trustworthy evidence in the interest of justice. So you got three things going here on a rule relaxation. The rules are going to be relaxed, they're not going to apply. So what are the limitations then on the judge considering a piece of evidence? Number 1, reliable, okay? Number 2, relevant. And number 3, in the interest of justice. So if it appears to be trustworthy, if it appears to be reliable, if it's relevant to some aspect of the case, okay? And if it's in the interest of justice, the judge can consider it. Outside of the rules of evidence, you know, the formal rules of evidence involving hearsay and authentication and things like that. And then you can see that E is the precursor to 104A. Proceedings to determine the admissibility of evidence under these rules or other law. And that is Rule 104A. Let's take a look at 104A then. With the qualifications of a person to be a witness, so do you qualify as an expert? Do you qualify as a lay witness in the sense that you have personal knowledge, that you understand the requirements of the oath, that you have a present recollection of what you're testifying to? These are all the things that make you qualified as a witness. If you're going to qualify as an expert, you have the requisite skill, knowledge, experience, training, education to be able to render an opinion on this stuff. Or the admissibility of evidence, which is what we're talking about now, or the existence of a privilege is subject to a condition. So we're talking about now the admissibility of evidence, that evidence specifically is Alcotest readings, and it's going to be subject to not only a condition, but 3 conditions, okay? Inspected according to procedure, certification or qualifications of the operator, test administered according to official procedure. So the admissibility of evidence is subject to a condition, and the fulfillment of that condition is an issue. That issue is to be determined by the judge. In making that determination, the judge shall not apply the rules of evidence, except for 403 or a valid claim of privilege. Now, valid claim of privilege is always going to be in play. Let's talk about 403 for a second. 403 deals with things that are a waste of time, cumulative evidence, evidence that is more prejudicial than probative, that type of thing. So evidence that's not, that wastes everybody's time, that's irrelevant, you would exclude that. You wouldn't have that go in because the case would never end. Okay? Now notice that evidence that's not relevant is already excluded under Rule 101. But 403 would also exclude irrelevant evidence as just being a waste of time. Okay? So 403 or a valid claim of privilege are really the only two rules that are going to be in play during the 104 hearing. So all the normal exceptions you'd raise about hearsay and the strict authentication rules and things like that, all that stuff's out the window, assuming that the evidence is it's relevant and appears to be reliable. Okay? If those two things are met, the judge can consider it during the 104 hearing. The judge may hear and determine such matters out of the presence of the jury. Okay? Everybody with me so far? Now look, as a practical matter, the 104 hearing in the context of a per se violation based on Alcotest evidence is the trial. Okay? That's the trial. Assuming that operation is not in play, everybody, the operation part has been proved. If the judge decides at the end of the 104 hearing, state's put its proofs on, defendant has put its proofs on, everybody's been cross-examined, at the end of that hearing the judge says, I'm going to admit the readings. If those readings are .08 or greater, the case is over. That's the end of the case. There is no defense that you can raise under New Jersey law at that point to rebut that evidence. The .08 coupled with operation within a reasonable period of time after the .08 is taken, that's the case. It's over. There is no defense that you can raise. Conversely, for the state, it's the same thing. If the judge will not let the Alcotest readings go in, the per se case is over for the state, except in a situation where the state might have blood evidence or something like that. But as a practical matter, that's the end of the per se prosecution for the state. I'm not suggesting for 1 second the prosecution couldn't go forward with an under the influence prosecution. But the per se part of it is going to be over. So in a very real sense, the 104 hearing becomes the trial. Now I want to give everybody some procedural pointers that I'd like you to keep in mind when you're dealing with this stuff. Some of it's a matter of professionalism, some of it's tactics. Let's just talk about professionalism for a second. It is vitally important that the record very clearly, unmistakably point out when the 104 hearing begins and when it's over. Why? Because during the course of the 104 hearing, all the rules change. There are no rules. You're not going to be objecting to hearsay or things of that nature. The burden of proof is reduced. It's going to be, in the drunk driving context, proof by clear and convincing evidence. Okay? So things that would be appropriate and necessary during the course of the regular trial are not going to happen during the 104 hearing, nor should they. Additionally, there are special rules with respect to the defendant. The defendant has a right to testify during the 104 hearing, but there are two things you got to keep in mind. Number one, the defendant is going to be treated like any other witness if he chooses to testify during the 104 hearing, meaning that the scope of his cross-examination will be limited to his direct testimony together with issues related to his credibility. Okay, so bias, interest in the outcome, things like that. Conversely, if he were to testify during his own case, the prosecutor would be able to ask him questions about anything related to the case. He's subject to cross-examination on anything. But if he testifies during the 104 hearing, he's treated like any other witness. That's important. That's under 104D. Number two, and this comes through the case law, the defendant is entitled to have testimonial immunity based upon his testimony during the 104 hearing. And by that I mean that the evidence that he gives during the 104 hearing is never admissible against him substantively. Never. Okay? The only use it would ever have outside of the 104 hearing is if the defendant decides, stupidly, to testify during his own case and says something at odds under oath during his own case that is different from what he said during the 104 hearing. Under those circumstances, his 104 testimony can come in to impeach him as part of his own case, but it's never admissible against him substantively. And it makes sense because, look, the whole point of the 104 hearing has nothing to do with guilt or innocence at all. You're dealing with an evidentiary issue. Are the conditions of admissibility for this piece of evidence satisfied? If they are, the judge will admit it. If they're not, the judge won't. And that's really kind of the only question that has to be decided during the 104 hearing. So these special rules for the defendant are in play. This is why it is vitally important that the record very, very clearly designate when the 104 hearing starts and when it's over. The worst thing you want to do is be in the middle of some hearing and people are objecting to hearsay and the judge who's reading this over on appeal, the law division judge, can't figure out what's going on. Are you in a 104 hearing? You're not in a 104 hearing? Do the rules of evidence apply? They don't apply? It's just an unprofessional way of dealing with these things. My sense is, look, it's your case. You want to tell a story in the most convincing way you can. There may be a logical flow to it, and it might be better for you to establish that your guy was driving, that your guy was under the influence of alcohol, throw in enough evidence to show that he was under the influence of alcohol. And then having established it, then get into the 104 hearing. And there's nothing wrong with that. I know other prosecutors prefer to do it right at the beginning, pre-trial, before they've done anything else, to do the 104 hearing to try to get the Alcotest results in. And I guess that's okay too. I don't really think there's anything wrong with it. The point I'm trying to make is, as the idea about when the 104 hearing occurs, I think is really just it's the prosecutor's call. Because it's the prosecutor's case. You have the responsibility for making your case. You should be able to do it whenever you think it's appropriate logically for you to tell that part of your story. Ultimately, under New Jersey Rule 611, the Rule of Evidence, the judge gets to make the decision about the sequence of witnesses, the mode and method of interrogation for the purpose of determining, the search for the truth and to avoid, needless presentation of cumulative evidence and that type of thing. So, at the end of the day, the judge gets to make the call. I don't think the defense counsel has any role at all in deciding when the 104 hearing is going to take place. I had a case the other day where we had an operation issue, and that was the whole case. And they were willing to, they wanted me to stipulate the state's case, which would have meant stipulating a BAC of 0.15 or something, plus stipulating he was under the influence of alcohol. And I'm thinking to myself, do I really want to do this? Because if I stipulate the case and I lose, my guy's going to get a 7-month suspension. If I tried the per se part of the case and I'm able to exclude the readings, even if I lose the case, he's still only looking at a 3-month suspension. So, it was a difficult call for me to make because, again, we have this one narrow issue. It's related to operation. Back to the 104 hearing, all right? So, denote on the record when it starts, denote on the record when it's over. Remember the special rules for doing it and the special rules related to defendants during the 104 hearing. Notice here's some case law dealing with this. Rule contemplates use of affidavits and other hearsay in such preliminary inquiry so long as the evidence appears to be reliable. Cardone uses the word reliable. You saw in 101 they use the word trustworthy. It's really kind of the same thing. A later case, State versus Dome, 1988, says basically the same type of thing in the conduct of the 104 hearing. The timing of the hearing we talked about a moment ago. Here's 611. The court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to make the interrogation and presentation effective for the ascertainment of truth and the least consumption of time and, I guess, for, cumulative type evidence. Although, stop to think about it. If the rules of evidence don't apply, then maybe 611 doesn't apply either. All right. Now, there are discovery issues that you can fight about in an Alcotest case, and that's perfectly okay. I've run into a couple of courts that they're not providing all the discovery. They're saying if you want it, we have it on a website, go look it up and print it out yourself. And if you want to play those games, that's fine. It's legitimate stuff to argue about, okay? What I want to talk about, though, are the areas where there should be no dispute. How you get the evidence is one thing. But what the evidence is going to be really is that ship has sailed, all right? Because the Supreme Court has told us what the discovery should be in every Alcotest case. They tell us twice, actually. They tell us in the body of the Chun decision, and they appended an order to the end of the case, there's the pinpoint site on it somewhere up there, that tells us what are the documents that should be provided in every single case to the defense. Now, these are referred to by the court as foundational documents, all right? And the idea that the justices had was that defendants could look through this and if they see some error in here, raise a challenge on a pretrial basis to the admissibility of the Alcotest, pretrial, all right? If they saw some defect in these documents. Now, I'm happy to report that most of the prosecutors, well, not the prosecutors, but their police departments, discovery clerks, they pretty much know what to send out and are able to give you either these documents or a pretty close facsimile to these documents, okay? And here they are, here's all 12 of them, okay? Notice for number 12, by the way, this Urco-Hart calibration is no longer Urco-Hart. I think you can use a different company now as a result of State versus Holland. Now, within this group of 12 documents, there's a subset of documents which are referred to by the Supreme Court as core foundational documents. It is the core foundational documents that must be introduced by the state during the course of the 104 hearing in order to satisfy the conditions of admissibility. Okay? Now, I just want to go backwards here for a second. Let's talk about this. Take a look at this cell again. This is from Chun. Device in working order have been inspected according to procedure, operator was certified, and tests administered according to official procedure. How is the state going to establish each of these? Number one, device was in working order and had been inspected according to procedure is going to be proved purely through documents. It'll be pure documents, pieces of paper among the core foundational documents, which will come in and satisfy that. It's just that the prosecutor has the right papers and plops them down in front of the judge. That element has been satisfied. It'll be satisfied by clear and convincing evidence if the judge is satisfied as to the bona fides of these pieces of paper. Operator was certified. That's going to be done by two things. A piece of paper, the card of the officer, which shows that he's currently licensed to operate the Alcotest, or at least he was on the date he administered the test, and the officer's testimony saying, yeah, here's my card, I'm certified, or at least I was on that particular day. And number three, test was administered according to official procedure. This is going to be proved almost exclusively through testimony, the testimony of the officer who performed the test. It's his verbal testimony that's going to establish this final condition of admissibility, all right? So, when we talk about the core foundational documents, they're really only going to be relevant in proving number one and number two of these three requirements, all right? Now, here's how the court discusses core foundational documents. Let's take a look. Our analysis of the general scientific reliability of the Alcotest is grounded, in part, on our expectation that there will be proof that the particular device that has generated an alcohol influence report being offered into evidence was in good working order, and that the operator of the device was appropriately qualified to administer the test. This requirement to test results be supported by foundational proofs for admissibility has been part of our jurisprudence since we decided Romano. So let's stop here for a second. Remember, I told you they're pretty clear about the procedure, but the underlying components of it, burden of proof, burden of production, things like that, they're silent on. I think it's a safe assumption they meant that the burden of proof be the same, the burden of production be the same. Okay. There, meaning in Romano, we demanded that as a precondition for the admissibility of the results of a breathalyzer, the state was required to establish, one, the device was in working order and had been inspected according to procedure, two, the operator was certified, and three, the test was administered according to official procedure. Now, I've told you that's not what Justice Handler said in Romano, but it's good enough for me. Okay, this is what Justice Howens thinks that he said. The foundational documents we conclude need to be entered into evidence, therefore, are few. Now here she's going to list three types of documents. The most recent calibration report prior to the defendant's test with Part 1 control, Part 2 linearity, and credentials of the coordinator performing the calibration. 2, the most recent new standard solution report, and 3, the certificate of analysis of the 1.0 simulator using the defendant's control test. Absent a pretrial challenge to the admissibility of an AIR based on one of the other foundational documents produced in discovery, remember I told you you can raise pretrial challenges to them, we perceive no reason to require they be made part of the record routinely. Now, I know a prosecutor, when he prosecutes these cases, he'll put all 12 categories of these documents in. He's never done it to me, but if he were to do that, I'd object, saying, look, this is cumulative evidence, it's not relevant, it's a waste of time, it's not necessary. Just put in the core foundational documents like the Supreme Court says instead of doing its needless presentation of cumulative evidence, okay? But I haven't had to confront him with that yet. That'll be my objection. I'll be interested to see how a judge rules on that. Now, here's the problem. Notice here the Supreme Court has talked about 3 core foundational documents. There's actually 6. Because there are other parts in the opinion that the court denominates other types of evidence as necessary for the admissibility of the Alcotest results. So at the end of the day, you actually have 6 different pieces of evidence that have to come in as core foundational documents, all right? Now, what I've given you here is a list of those 6 documents and the pinpoint citation in the Chun decision where the court designates them as core foundational documents, all right? So, just to review, the qualification card of the operator, which you're going to need to show that he was qualified to operate the instrument. Most recent calibration report from the state police. Most recent standard solution change. Certificate of analysis of the control test. All that stuff was there. Alcohol influence report. Worksheet A. Everybody got it? Those are the documents that you're going to need. Now you see the Supreme Court a moment ago when we were just looking at this, they mentioned 2, 3, and 4, but 1 is in there, it's necessary, that's how the police officer proves he was qualified. Later on in the opinion, you see at page 134 and then 150, 151, they talk about the AIR and the worksheet A that have to go in. Let's go through these then. Here is the card of the officer. Now, look, the card is good for the year you're in plus 2 calendar years. So they always will expire on December 31st sometime. In this case, this officer was first certified in 2005. That means he's good for the balance of 05, all of 06, and would expire on 12/31 of 07. You can see that he sneaked into the Ocean County Police Academy, though, on December the 19th, took a one-day refresher course, which would be good. He'd be good for the balance of the short balance of 2007, all of 08, and would expire on 12/31/09. The New Jersey Administrative Code provision in play here is codified in NJAC 13:51-1.8D, as in drunk driver. 13:51-1.8D. That NJAC provision renders the test results inadmissible if the guy's card was expired when he administered the test. Okay? The case is over at that point. It's just not admissible. Remember, it's not the case law, it's not by statute, it's NJAC that requires that. Now, let me just give you another little issue that you may want to think about. You're going to get in your discovery package 3 different sets of cards. Okay? You're going to get the card of the operator here. You're going to get the card of the breath test coordinator who went in and calibrated the machine. You get his card. And you will get, as part of your discovery package, the card of the officer who last changed out the solution before your guys' test. And if you go back and look at the list of discovery from Chun, in number 1, you can see the first thing they tell you is new standard solution report of the most recent control test solution, okay, and the credentials of the operator performed that change. Now look, the first part of this is a core foundational document, okay? This part is not. The credentials of the operator performed that change. The Supreme Court did not designate that as a core foundational document. You're going to get it in discovery, but the prosecutor does not have to put it in evidence. What I'm telling all of you is this. If that card is expired when the officer swapped out the solution, they got big problems. Because not only is your guy's test not admissible, but the other 24 people up to your guy's test that they tested, they're not going to be admissible either. For somebody to change solution on an Alcotest, the only requirement is that the individual be a licensed operator of an Alcotest, have an Alcotest operator's card. That enables you statutorily to change solution. But that's not what the state police want. They want the chiefs to select officers that will have attention to detail, many times traffic officers, because they just have that kind of mindset. These people will be designated to come in and take the necessary steps to take the thing apart, wash it, clean it, dry it, put the new solution in, test it. It's a time-consuming, detail-oriented job they don't want every Tom, Dick, and Harry doing. So certain officers will be designated to the department and tasked with that responsibility. The only thing they have to have is a card. If that card is expired, they don't have the legal right to change the solution. Everybody got that? So that's why you always have to check that, notwithstanding the fact that it's not a core foundational document. All right. So, inadmissible if this is expired. I want to go through now the information from the state police on the calibrations. Remember that before the publication of the Chun decision, the recalibration of the machine occurred as a matter of SOP by the state police once a year. Chun stood for the proposition that the Supreme Court was not happy with that and felt that it would be better that the machines be recalibrated every 6 months. So that came out of Chun. It required a doubling of the size of the number of state police breath test coordinators. They went out, recruited them, trained them, and I think they went from having 4 or 5 people to having like 11. And that enabled them to do this stuff on a 6-month basis. Now, it's a very time-consuming process. The production or the productivity of the typical breath test coordinator is 2 machines a day. They don't wear uniforms, they drive civilian clothes, they show up. They bring their own simulators and their own simulator solution. They don't use anything that's in the department. Again, as a safety check. They bring all their own equipment. They show up in the morning, recalibrate an instrument, leave, have lunch, drive to the next department, do the second machine, and that's pretty much their day. Okay, again, because it's a time-consuming process. Now, I want to go through the steps one by one so you can just have a mental image of what the trooper is doing versus what these documents mean. What's the first thing that's going to happen? The trooper is going to put solution in a simulator, which he's brought with him, new simulator, strength of 1.0 solution, okay? And then he's going to tell the instrument to calibrate itself. And what he's essentially saying to the machine is, look, this is 0.10 solution. Please adjust yourself so when you see a solution strength of this level, that is a 0.10. It's exactly the same thing as when you get on the bathroom scale in the morning and it's a little bit off and you adjust it back to 0 again, or in my case I make it minus 10 pounds, but for the normal person you put it back to 0, okay? It's precisely the same process. You are telling the instrument, this is what a 0.10 looks like. When you see this, adjust yourself to 0.10, okay? This first document you see here, Alcotest 7110 calibration record, is the only evidence that you get that the trooper actually performed this function, had the instrument recalibrate itself to what a 0.10 is. You'll see here that the history of this was sequential file number 203, I think it's the number there. And you can see he performed this function on October the 23rd, 2007. And you see that number 4 there. That means this is the 4th time in the history of this machine that this instrument has been calibrated. Now, you'll always see that this is going to be one more because the initial calibration of the machine takes place at the factory, the Draeger factory, all right? Thereafter, all the calibrations are done by the state police. So this is the only document you get that shows that the instrument was done. The serial number of this instrument is ARWF0359. The trooper utilized his own simulator solution right here. I can't read the number, but he brought it with him, put it in his own simulator, put it on the instrument and said, okay, when you see a vapor from this solution, adjust yourself, that is what a 1.0 is, okay? Now, having recalibrated the instrument, the next step is to see whether it's working or not. So what he'll now do is test the instrument to see whether it recognizes what a 1.0 solution is. And you can see that he has done that. This is the next step. You can see this is sequential file number 204. This is the very next thing he did, same date. And this is the 3rd time in the history of this machine it has been had a control test done to see whether or not now it is accurately reading what 0.10 is. Now you can see from the simulator here, you would expect, and you do receive very tight readings. You're going to expect either 1.0s or 1.01 or 0.99, something very, very close to the ideal being 0.10. Remember that the acceptable range could be as high as 0.105 and as low as 0.095. But within that range, when you're dealing with an instrument that was just calibrated has brand new solution on it, you really would expect very, very tight tolerances. And you can see that that was the results here. Notice, by the way, the temperature range, 0.2 degree, can be as high as 34.2, as low as 33.8. It has to be within that range. Anything outside of that range, the instrument will not function. It'll shut itself off. 34 degrees is supposed to be the ideal temperature of human breath, okay? So you can see here that the trooper then tested the instrument to make sure that it was reading properly, and in fact has done so. All the readings are within the appropriate level. Now the next thing the trooper is going to do is he has brought with him other solution strengths. He has a simulator that has 0.04 solution in it. He has a simulator that has 0.08. He has another one with 0.06. The whole purpose of this is to test these other solution strengths to see whether or not the Alcotest is accurately gauging the strength of these other solutions. It's additional proofs that it's working properly, okay? Now this is referred to as linearity testing because if you graph this stuff starting at 0, the points on the graph will just be a straight line, okay? 0.04, 0.08, 0.16, it's a geometric progression essentially. Alabama, which has also an Alcotest, they actually go as high as test as 0.32, double of 0.16. I always make the joke that they do that because of moonshine, but nobody has ever laughed at that joke yet, so I'm not making that joke anymore. But everybody understand why they call this linearity, because of the line. If you started the port at 0 and went out on a line, it would just be a straight line graph. Again, you would expect, since the instrument has just been recalibrated, that you'll have very accurate, tight readings here. So you can see the linearity testing has occurred here. This is the next sequential file number, 205, I guess we're up to. Same date. This is the third time there's been linearity testing on this instrument. And you see, looking down here, that these are all very tight tolerances. These are the 04s, 2 tests of 04, they're all very close. These are the tests here with the 0.08 solution. And these are the tests here with the 0.16 solution. Okay, all very, very tight tolerances, very close to the 0.04, 0.08, and 0.16 BAC that you would expect. Notice that the temperature in most of these instances is exactly what it's supposed to be. It's 34 degrees centigrade. Okay? Now you'll receive in your discovery packages forensic backup to show that each one of these solutions was tested by the New Jersey State Police Forensic Laboratories and shown to have the proper strength of mixture of alcohol and water that'll produce a vapor of 0.04 or 0.08 or 0.16 when heated to 34 degrees. Okay? So far so good? All right. The next thing that's appropriate for the trooper is his cards. I don't even look at these things normally. Here are the cards of the trooper. Now just a little background on this. In the era when Trooper Snyder was working, in order to become an Alcotest operator, you first had to be a breathalyzer operator, and then in order to become a breath test coordinator, you had to be an Alcotest operator. So he has all 3 of those cards, evidencing his qualifications. Now the newer troopers, you'll only see they won't have any more breathalyzer cards. You'll see that they get 2 cards, one for their Alcotest and the other one for area breath test coordinator. I don't even look at these things. It's inconceivable to me that the state police would allow a card, a trooper's card to expire. I can't see that happening. It's probably malpractice, but I just don't even bother looking. But you get this as part of your package. Young prosecutors forget to introduce this in evidence all the time, okay? Now, let me just stop for a second here, because I should have mentioned this before, but I want to talk about it now, okay? This is a very uncomfortable, nasty thing we have to talk about, but I'd be remiss if I didn't bring it up. So let's discuss it. We get to the end of the case. The prosecutor has put his case in the 104 hearing, all right? The evidence is going in. Now, as a defense attorney, you might have decided to cross-examine. That's fine. You might have an affirmative defense you're going to raise. That's fine, too. Again, we're still in the context of the 104 hearing. Or you may see the state has left something out, like these cards, okay? Whatever you're going to do as a defense attorney, I think what you've got to do first, before you make any argument at all, you've got to pin the judge down. And you've got to say, Your Honor, look, has the state, do they have anything more to go in? Because I want to make sure that they're done before I, make my argument here. Because the last thing I want to do is raise some issue and the prosecutor says, oh, I forgot. Judge, give me 2 seconds and we'll put that in evidence, okay? It's bad enough that we have one prosecutor here. I don't want to have 2 prosecutors, me and him, where I have to remind him about what he didn't do, and then you're going to give him a chance to correct it. At some point, even a speeding train has to come to a stop. So I just want to make sure the prosecutor has nothing more to offer, because when I make my arguments, that's it. Now, this next document is of critical importance because it's a little bit tricky. Let's go back to the trooper again, okay? He's changed the solution. He's run control tests. He's run linearity testing on it, okay? Everything looks like it's great. Now he's getting ready to leave. The last thing the trooper's going to do, remember I told you he's been using his own solution that he brought with him up to this point. Now he's going to stop and he's going to go back to the cops and he's going to take the solution that the police have in their building, okay? And he's going to take the police solution and put it on the Alcotest. And if you note here, take a look at the simulator solution, 06H035. That is not coming from the state police. That is simulator that's in possession of the local cops. He's going to take simulator solution out of the local cops closet. That's going to be solution 06H035 and put it on the instrument. And then he's going to say, okay, cops, I'm leaving now. I'll be back in 6 months. I just put new simulator solution on here, so you're good for the next 60 days, or excuse me, write that, the next 30 days, or the next 25 drunk drivers, whichever happens first, okay? Now let's think about this for a second. When are the times that you have to put new simulator solution on an Alcotest? I only know of 4 times, okay? Here they are. Number 1, the passage of time, 30 days. The instrument knows, it's a computer. It knows what today is and it knows what 30 days from today is. You put new solution on it, knows 30 days from today, exactly 30 days, I'm going to shut myself down. I won't allow any more tests to be done until I get new simulator solution. Why? Well, the state police felt that, their forensic chemists felt the alcohol would dissipate over that time period. Every time you use it, expose it to the air, you know, some of the alcohol is being dissipated into the atmosphere. So 30 days is the maximum shelf life for the simulator solution. So after 30 days, it needs a solution change. Number 2, it's 50 test sequences, but typically that's going to relate to 25 drunk drivers, okay? If you bring in drunk driver number 26, the instrument will shut itself down and say, no, I've had too many test sequences, I need a solution change, okay? So let's just keep it simple. 30 days, 25 drunk drivers, each of those occasions you'll need a solution change, right? Next, control test failure. You're going through the process, you know, they test the guy, get good samples, they come to the end, the instrument tests itself, but one of the chests of the simulator solution shows a .094. Remember I told you the range can be as high as 105, as low as .095. If it comes back as .094, shuts itself off, says, can't do it, no more testing, need a solution change, okay? If you get a control test failure, the instrument will shut itself down, okay? Can't do anything until it gets a solution change. The final way you will get a solution change is here. When the troopers come in, recalibrate the machine once every 6 months, the last thing they do before they leave is they put on a new solution. So, if your idiot gets arrested 2 days later by the local cops and they bring him in and test him, the last time the solution was changed on that machine happened by the state police. And it may be that way for as long as 29 days, all right? If that occurs, this becomes a core foundational document, because this is the most recent standard solution change. Everybody got that? Now, in most cases, if your guy gets arrested 31 days out, or 2 months, or 3 months, or 4 months out, this is not going to be relevant to anything. It just drops out of the picture. It's not a core foundational document. It doesn't have any relevance at all. What's going to be relevant is the solution change that was done by the local police officer. But I just want everybody to understand that there are circumstances that this could be a core foundational document. Everybody understand that? All right. Now, in our particular case, the trooper, again, we're dealing with October the 23rd, 2007. This is sequential file number 206. It's the 34th time in the history of this instrument that it has had a new standard solution put on. Again, he tested it. And as you would expect, you're getting very, very tight readings, 1.0s and 9.9s. Okay? He signs his name, Trooper Snyder, and I'm leaving. I'll see you guys in 6 months. Got it? Now, time goes on, and in January, so we're talking about 3 months later, the instrument needed another solution change. Now, you take a look at this. You can see what's been going on. That's the number of times they've changed the solution on this machine in its lifetime. So this is the 37th time it's happened. When the trooper did it, it was the 34th time. So they've had 2 other solution changes in the interim, in the 3-month period. You can also see how active the machine has been. When the trooper put the solution on it, it was the 206th function this instrument had done in its lifetime, sequential file number 206. When they changed the solution in January 20th, it was the 247th time the solution had been changed. So that's, what, 41 functions that the instrument had, 2 of which were solution changes, okay? This solution change occurred on January the 20th of 2008, and you're going to see this is going to be relevant to the date that the defendant gets arrested. This will be the most recent solution change. So this is going to be the core foundational document. The officer who changed the solution is a guy named Stephen Simon. I know him personally. He was an officer in the Air Force. He's a typical person who would be selected by the chief of police and tasked with the responsibility of changing solution, because he's just the type of person who's responsible, mature, and knows how to pay attention to detail. Okay? And what does it say? That Officer Simon came in sometime on the 20th of January and changed out the solution, tested it, everything's working fine. So this instrument's going to be good for the next 30 days or 50 test sequences, next 25 drunk drivers, whichever happens first. Okay? This will be the core foundational document. Here is the certificate of analysis for the simulator solution. Now notice the trooper, when he left, he put on 068035. He got that out of the closet at the police department. 3 months later, the local officer got out of the same batch, 068035. Okay, that's the simulator. How do we know that 068035 is properly constituted, that it has the right constitution or the right solution strength of alcohol and water? Okay, well, our proof is right here. Now, this is a core foundational document from the New Jersey State Police Forensic Laboratories showing that 068035 has been tested by the New Jersey State Police Forensic Laboratories and has within it the correct solution of alcohol and water. Let me explain this in a different way. This is, wait a minute. This is a CU34 simulator, okay? Right here. CU calibrating unit, 34 degrees centigrade, CU34. That's the technical name for the simulator, CU34. It contains a mixture of water and alcohol, okay, which will be clear, you know, like water and alcohol would be. There it is, right there. The state police test that solution strength, and they will test the relationship between how much alcohol and how much water is in here. Typically, it'll be mixed to a strength. I think that the ideal is, I can't read it on here, there is a certain concentration of alcohol and water that if you mix it together, and then you heat it to 34 degrees centigrade, and you create a vapor in the headspace of the simulator, right up here, okay, which will be filled uniformly with molecules of ethanol. Those molecules of ethanol will have exactly the same strength as a human being who would have a BAC of 0.10, okay? They know that. They know that with absolute precision. And they know it for how much alcohol and water they have to mix together to get a 0.04 strength of vapor, a 0.08 vapor, 0.16. You saw that being done earlier on. Here, they're just interested in 1.0 vapor. Okay, so they've tested it. There's the proof that it was tested. 068035 was tested. It has exactly the right strength of solution of alcohol and water, such that if you heat it to 34 degrees and create a vapor in the headspace, the molecules here will be exactly the same as a human being that at 0.10. It'll simulate a human being that has a 0.10 BAC. Okay? That's the proof that makes this accurate. It all gets tied together with the alcohol influence report. Now, the idiot that they arrested here, this happened on January the what? Let me see, date 27th. Okay, very good. So this was within 7 days after they put the new simulator solution on. Now, if you look here, notice that the file number when they swapped out the solution 8 days earlier was 247. They've arrested this idiot 8 days later, and it's now 249. What inferences do you draw from the productivity of this police department when you see those numbers?
A lazy department.
Lazy department, right? They're not out arresting drunk drivers. So the point is that you can see that these sequential file numbers, this is not a particularly active department, or at least hasn't been in the intervening 7 days. Okay? Everybody got that? Let's just go through these, let's go through the fields The top here, you can see the sequential file number, the same number as here, 249. This is the 249th function this instrument has ever done. Pedigree information here, date of birth, age, male. None of this really matters anymore. It should have been important because of females over the age of 60 are not required to provide as big a breath sample as everybody else because of some physiological changes in their bodies at that age. That's never going to happen, though. We have to just kind of account for that, you know, kind of off the books, because the software changes that would require this are never going to be made now as a result of some action by the Supreme Court. So we're kind of stuck with what we've got, with no software changes being made at all. This information here, height and weight, has no bearing on anything except for statistical purposes. This is a big guy, 6 foot something and 295 pounds. I hope he wasn't fighting with the cops. Now, I just want to mention something to you. Keep this in the back of your mind. This is where data downloads can be very, very important. In my estimation, they come up important in 2 reasons. Number one, when the officer started typing in the pedigree information, name, address, all that stuff here, okay, the instrument times itself in so that the first keystroke that the officer hit, the time is recorded. So many times if you get into a 20-minute issue, you know, the officer says he was watching the guy, but this will show that he wasn't watching the guy. He was typing in data into the Alcotest. So if his back is turned or something of that nature, he's obviously not looking at the defendant while he's typing in it. It's a good area for cross-examination if you can get a hold of the data download, and it'll tell you exactly at what point he had the first keystroke on there. Then compare that to the times that they gave you for the 20 minutes, all right? There's another reason why I want you to take a look at the data downloads, but I'll come to that in about 2 seconds. So this is all pedigree information entered by the officer. Notice that the arresting officer here is not the same as the officer who did the test. We showed before the card of Officer Everest who performed this test. The arresting officer here is a guy by the name of Andrew Lee. The second portion here is all historical information, which you've seen before, talking about the last time the instrument was calibrated. And you saw earlier on that it was in October of 2007. The last time the solution was changed, which was on January the 20th, and now today's date, January 27th of 2008. Okay? We use wet in New Jersey. Some states, Alabama, use gas, but we just use wet. CU34, calibrating unit 34 degrees. 1.0 solution, there it is, 06H035. Same solution that was put on by Officer Simon 7 days earlier. Same solution that had been utilized earlier, even earlier, by the Trooper Snyder. This is the serial number for the CU34. Now, notice that the procedure here utilizes a technique called bracketing. Bracketing goes back to the era of breathalyzers. And in breathalyzers, basically the troopers would show up on day 1, test the breathalyzer, leave paperwork there to show that it was working. Then your guy would be arrested at some point after that. And then they would come back 30 or 60 days later, test it again. And if the breathalyzer was working okay on day 1, then it was working 30 or 60 days after your guy was tested. The inference is if it was working good then, it was working good before, it was working good after, then it must have been working okay on the day your guy was arrested. That's the idea of bracketing, okay? The theory of the Alcotest is that every test is bracketed. Every single test, okay? So let's take a look. See what happens. First thing that goes on is the instrument is going to blow out any residual molecules of ethanol that are inside the testing chambers. It does this through what they call the ambient air blank. It takes air from the room, blows it into the instrument to blow out the molecules of ethanol. Now, sometimes your guy's sitting in a little tiny room, and he's kind of nodding off like this, there's poor ventilation, and the molecules of ethanol coming out of his body will contaminate the air and actually get sucked into the machine. You'll get a failure message when that happens, and the only thing you can do basically is just kind of clear the air in the room, literally, and have it until the samples can actually blow out all the ethanol molecules. The next thing that happens is that the instrument, after all the molecules of ethanol have been blown out, it's going to take molecules of ethanol produced by the simulator, okay, right here. Heated to 34 degrees, they stir it up, a vapor comes up at the top, like that, trapped in the headspace. The instrument will then suck out a sample of the molecules of ethanol into the testing chamber, and then perform 2 tests on the same molecules concurrently. Concurrently? No, consecutively, one at a time. First test it's going to do is test it through infrared technology. After it's done testing it through the infrared, it will then take a sample of those same molecules of ethanol, put them in a different chamber, and test them through the technique of electrochemical analysis, all right, like a battery. Now, these are 2 independent methods of testing the same sample. And the idea is that if you have 2 independent technologies testing the same molecules of ethanol, and they come back with results that are close to each other, the idea is, well, you know, the likelihood is probably an accurate reading. Sometimes, you know, you'll be blowing things into the instrument that may be, it might pass the test for one type of technology, but not the other. For example, let's say you're dealing with a diabetic, and maybe the sample has isopropanol in it as opposed to ethanol, or molecules of isopropanol. You know, there's really only, I think there's only 1 electron's difference between those 2 molecules. But the bottom line on it is that the instrument, you know, one of them would be sensitive to isopropanol, the other one is not. Bottom line is 2 technologies testing the same samples of ethanol. If the results are close to each other within an acceptable range, inferentially it means that it's probably an accurate reading. And you can see here, we go back to this, that the electrochemical result on this sample from the simulator was 101. The infrared tested it at 0.10. They're well within tolerance of each other. Okay? So the inference is that the instrument is working fine at the beginning. Notice the temperature is within the range of the 34 degrees. Ambient air now goes into the instrument and takes the molecules of ethanol that were produced by the simulator and blows them out. Now the human subject provides a sample. Remember that the minimum criteria are 1.5 liters of air delivered over 4.5 seconds. That's the minimum. The idea behind that is that you want to get the so-called alveolar air, the air from the lowest part of the lung. As the guy's blowing into the machine, these molecules of ethanol are going to travel from the bottom portion of the lung up through the lungs, through the trachea, out of the mouth, into the receiving hose, and into the testing chamber. The molecules of ethanol at the bottom of the lung are the ones that are physically closest to the arterial blood supply in the human body. That's why you want to value those, because they kind of give you the closest approximation as to what the BAC is, the blood alcohol level. So the idea is over 4.5 seconds, 1.5 liters of air, most human beings are going, the final sample they're going to blow into the chamber will be coming from the lowest part of the lungs. Now obviously the longer you blow, you know, the better the sample is going to be, in the sense that you'll be getting molecules from the bottom part of the lung. In this particular case, this defendant had, I don't know, 3.8 liters of air over 5.4 seconds. I'm having trouble reading the numbers, but you can see it is well over the minimum criteria that are required for a valid sample. The instrument gets these molecules of ethanol from his body, tests them, and finds 0.175, 0.175 on both occasions. So no tolerance here at all, they're identical. The ambient air blank comes down and blows these molecules of ethanol out. They were introduced by the human subject. The human subject now is required to give a second sample. You can see on this occasion 3 liters of air over 5.9 seconds. Results consistent with the first test, 0.174 and 0.171. Okay? Notice, by the way, that the test administered to the defendant, where he gives his first sample, everything's noted in time. The time up here, time of arrest, is entered by the police officer. There's a 20-minute lockout period between the time of the reported arrest and the time the first sample can be taken. The reason for that is to allow 20 minutes to go by to let any residual alcohol in the test subject's mouth to dissipate. Okay? We've gotten 2 sample results acceptably from the test subject. Ambient air comes down and blows out the molecules of ethanol. And now the simulator is asked once again to bracket this by testing itself once again with molecules of ethanol from the simulator. It comes in from the simulator, tests itself, and you can see the results are within the acceptable range. 0.9899, I think, are the results. And then the last step, it just blows the molecules of ethanol from the simulator out into the atmosphere. So the bracketing occurred here and here. It tested itself before, it tested itself after. The inference is that these are accurate results. The result that utilized in evidence is going to be truncated, meaning you take the lowest of the 4 readings, chop off the last number. Don't round it, chop it off, truncate it, And you had, no matter how you cut this one, he's a .17. There's the signature of the officer who administered the test, time and date. Copy given to subject. Chun suggests that the police give a copy to the subject as part of the procedure. I wouldn't waste my time on raising that argument unless I was really desperate, but I think it's a non-starter. Everybody cool? Now the last thing we've got here to be concerned with is the worksheet A. This is going to be with us again as a result of something that's the topic of another course. Worksheet A must be submitted even in the case where there's going to be a plea. It's the responsibility of the prosecutor to attach worksheet A to the alcohol influence report as either a core foundational document during the trial or as an exhibit, as a plea. This is again required in the case law through Chun. What's interesting is when the police utilize a little calculator, it'll have a timestamp on it. That timestamp can be very, very important sometimes, because many times you'll see that the timestamp that they ran on the test results when they're checking for worksheet A to see if they're within tolerance, you'll see that it actually occurred while they were still testing the guy. There's no coordination between the times, and if you're in a situation where the police are having trouble figuring out what time it is, that's a good way of kind of throwing some doubt on it. All right? If the results are not true, the results are inadmissible, the police will either have to start over again or take him to the hospital or something like that, but the test results are no good under those circumstances. Everybody cool? So these are your basic core foundational documents. Now, I'm going to just kind of slide by this missing discovery and duty to do that. I don't want to get into discovery fights in our discussion here, except to the extent saying, you know, looking at HOLLOP and looking here, I think you really have an affirmative duty to go forward and tell the state if you're missing some documents. It's just really kind of, I think that's what the case law demands of you. HOLLOP motions are the appropriate way of dealing with things if you're missing a piece of discovery. State versus Wolf, which is a fairly recent appellate division case, doesn't mention HOLLOP at all, but just suggests that if there is missing discovery, you're really going to have to make an argument that the state's failure to give that discovery prejudiced you in some significant way. You would have hired expert A or called witness B. In the absence of some substantial showing of prejudice, the judge's discretionary call in an evidence fight is, you know, for failure to provide a piece of evidence. If the judge wants to let the state cure that, usually it's going to be okay in the absence of some showing of prejudice. Take a look at State versus Wolf for that proposition. Okay, so let's go through a couple of the affirmative defenses that you can raise. One of them is whether or not the test was administered within a reasonable period of time. And I know this sounds apocryphal, but you get occasions where the cops will have to drive the guy around the county until they can find a machine that actually works. You know, they get to the end and they get a control test failure, so they have to drive them to the next town over. There they ran out of mouthpieces, they take them to another town, that town needs a solution change, you know. And it could be 3 or 4 hours before they finally get to the point where they can get the guy a test. Lots of times you see refusals in those cases because the defendants are mad because the cops are not letting them go to the bathroom and things like that. But one of the defenses you may want to raise is that the test was not administered in a reasonable period of time. The case law that establishes that goes way back to 1987, State versus Tissio. Tissio saying that the test has to be administered within a reasonable period of time. The main case interpreting that is State versus DeFrancisco. It's important because it actually worked as an affirmative defense there, where the state just didn't have any evidence at all that the test was administered within a reasonable period of time, and that was sufficient for the Judge Haynes to acquit this individual, the late Judge Haynes, at that time the assignment judge of Burlington County. So I commend to you the DeFrancisco plus the related cases dealing with the requirement that the test be administered within a reasonable period of time. Now, we talked about the elements. So the first one we're going to talk about, the device was in proper working order. Remember I said it's going to be all documents all the time. Here are the core foundational documents. The most recent calibration report from the state police, which is, you know, the calibration, the control tests, you know, all that stuff we talked about. Most recent standard solution change report prior to the defendant's test, and in this case you saw that happens 7 days earlier in the test of the defendant we're talking about here. There's a reminder here that sometimes that's going to be coming out of the state police when they change the solution, if it's within 30 days after the time they change the solution, or 25 drunk drivers. Certificate of analysis used in defendant's control tests. And I showed you the certificate of analysis that they tested this 068035 and it had the appropriate strength of solution. The alcohol influence report and worksheet A. These documents together will demonstrate that the device was in proper working order. Everybody okay? I don't know really what more the state has to do except, put these documents in front of the judge. You may want to ask the officer, what's this, just to have a little record of what they are. But the officer doesn't have to know a whole lot because the rules of evidence are relaxed, okay? And that should satisfy that component, assuming the judge finds all these documents to be otherwise reliable. Operator was certified. This is going to be proved by documents and testimony, particularly the card of the officer, which we talked about, plus his own testimony that he's licensed to operate these instruments, or at least he was on the date that he tested the defendant. Remember NJAC 1351 1.8D that I talked about before, rendering the results inadmissible if the card was expired. Now, was has to performed according to official procedure. Remember, the official procedure has been given to us by the Supreme Court in the body of Chun. They tell us what the official procedure is. In order to establish this is going to be 100% witness testimony, it's going to be the operator. The operator has to testify. He's an indispensable witness. You can't use surrogate witnesses in New Jersey, and that's the holding in State versus Riemann. Here is the official procedure with respect to 20-minute issues. Remember, the operators have to wait 20 minutes. Here's that explanation as part of the official procedure. Operators have to wait 20 minutes before collecting a sample to avoid overestimating readings due to residual effects of mouth alcohol. Software is programmed to prohibit the operation of the device before the passage of 20 minutes from the time entered as the time of the arrest. Operator must observe the subject for 20 minutes to ensure that no alcohol has entered the person's mouth while he or she is awaiting the start of the testing sequence. In addition, if the user swallows or regurgitates, or if the operator notices chewing gum or tobacco in the person's mouth, the operator is required to begin the counting anew. You will win more cases with 20-minute issues than anything else, primarily because the police do such a terrible job of documenting the 20 minutes. They don't understand it. They don't write it up right in the reports. And they're not normally going to be put in the crucible of a trial where they're going to be cross-examined on these issues. All right. One police officer, this is State versus Filson. I commend you, anytime you have a 20-minute issue, bring a copy of State versus Filson. This is the case written by the same judge we talked about earlier on in State versus Woodruff, Judge Oster, who's now in the appellate division. And all I can tell you in this case is the state lost because they were only able to account for 18 and a half minutes of tape of what the defendant, watching the defendant for 18 and a half minutes. They couldn't come up with that last 90 seconds. And as a result, the state was not able to satisfy that condition. Notice that Judge Osterer assumes that it has to be proved by clear convincing evidence. Take a look here. Discrepancy time recording that there was significant evidence to establish clearly and convincingly that even absent departure to stow the cell phone. So even Judge Osterer was assuming that the burden of proof is clear and convincing evidence here, although it's never specifically said in Chun. And I'm not advocating that it isn't. I'm just saying that we're all assuming that. So bring a copy of Filson with you if you have a 20-minute fight. Pre-test procedure. Assuming the results of the control test are within established parameters, the instrument will prompt the operator to collect a sample. New disposable mouthpiece. Many times the prosecutors will forget to ask the officers about that. It requires a new mouthpiece every time. Why? Because it has nothing to do with sanitary issues. It has to do with residual, saliva and things like that, which could contaminate the next sample. This is what I was talking about before, where you get to the end, everybody's rested, you say, Judge, the state cannot prove that they operated the machine according to official procedure because there's no evidence before the court that they changed mouthpieces every time. And the prosecutor says, oh, well, I can fix that right now. Can I just ask the officer a couple more questions? I mean, it's so unfair, but that's what you have to kind of paint everybody into a corner on before you get into this stuff. So, new disposable mouthpiece, remove cell phones and portable electronic devices from the testing area. Lots of times, if your guy had a cell phone in his pocket, I've had clients actually texting in the testing room. your guy's going to have to testify. And remember, during the 104 hearing, he's going to testify on the basis that he had a cell phone in his possession, but it's for the limited purpose of the admissibility of the Alcotest results. So remember, his testimony, his cross-examination can be limited to that particular issue. I don't know if this next part is of relevance, because if the state is satisfied that the defendant gave a good sample, then the fact of what he read to the guy is not going to come up. This comes up in the context where there's a refusal, especially in a language issue where the guy doesn't speak English and they were reading in English, but he didn't understand what he had to do to give a good sample. I think that's probably a really good defense you could raise along the same lines as State versus Marquez. But for here, it's not really relevant in terms of the procedure, assuming that the guy gave a good sample. At post-test, worksheet A, 4 decimal places, okay? Not 3, not 7, 4. Somehow the appellate division read over Chun, and I've read Chun 1,000 times. I've never seen this in there, but they figured it out. They're very smart. The Supreme Court wants you to figure out worksheet A to 4 decimal places, okay? So if you're going to do the numbers yourself, 4 decimal places, all right?